It's July 2024, and we still have a lot of open questions about how the Corporate Transparency Act applies to companies that exist or may have already terminated. What do we do now, and has there been any guidance? Hi, I'm John Strohmeyer with Strohmeyer Law, where we help our clients leave no unfinished business. While I am a lawyer, I'm not your lawyer, so don't take the advice of some talking head on the internet for your own uses. Make sure you talk to your own advisor about your specific circumstances. We're going to be talking about how the Corporate Transparency Act may apply to some of your entities, especially if those entities may have been terminated early. But before we get into it, don't forget to like, comment, and subscribe. We are following along with what FinCEN is putting out in terms of their guidance and trying to keep everyone updated so they know what to do. Now, FinCEN has released some updated guidance in the form of some new FAQs here in July 2024. We're going to talk about what those questions are so that hopefully you can make some correct decisions about what needs to be done. Remember, if we don't address this, we're potentially creating a future fight with FinCEN over having filed or not filed this. We're also creating a potential loss if we have to pay any penalties to FinCEN if these don't get done. So let's make sure that we're getting all these filings done because, like it or not, this has not been held unconstitutional for everyone yet. So until you get a Supreme Court decision, you are going to be obligated to file these reports for your entities. So let's get into those questions. Question number 1, do beneficial ownership information reporting requirements apply to companies created or registered before the Corporate Transparency Act was enacted on January 1, 2021? Yes. Now, this really isn't something new, but it is a question they released. Those reporting requirements apply to all companies that qualify as a reporting company, regardless of when they were formed or registered. They're not required to report beneficial information to the extent that they are exempt or they cease to exist as legal entities before January 1, 2024, which is when the reporting requirements went into effect. At the beginning of this year. So what this means, entities that existed before the enactment, January 1, 2021, yes, doesn't matter how old the company is. If it still exists, then your company is going to have to comply or otherwise be exempt from the reporting requirements of the Corporate Transparency Act. So even if it was formed in 1908, you're still going to have to file and report with FinCEN, the beneficial owners for that company. If it was formed between 2021 and 2024 and still exists into 2024, yes, you're going to have to report if you are not otherwise exempt. What if you have a company that ceased to exist before January 1, 2024? Does it have to report to FinCEN? Well, it's going to depend on how it ceased to exist. Now, generally, companies don't have to report their beneficial ownership information to FinCEN if they ceased to exist before January 1, 2024. So what this means and what FinCEN is looking for is that they completely finished the process of formally dissolving and nothing is left. Now, a company that has ceased to exist before those reporting requirements went into effect, well, they just weren't in effect. They were not in existence during the applicable time. Now, something that's been coming up as an open question, which we didn't have good guidance on until July 2024. Well, what if that entity was administratively terminated? It wasn't formally terminated, but you just forgot to file some paperwork and the state just went ahead and said, well, you're terminated until you have gotten your updated tax returns or some other form filed with the state. That is not going to be treated as a formal dissolution. What the guidance that we've received from FinCEN is going to say is that what you're going to do is actually still have an existing entity. And because that entity still exists, even though it was an administrative termination, you really haven't formally terminated. So if you're in a situation where your entity has been administratively terminated, you're still going to have to report your beneficial ownership information. Why are they thinking through? Why did they come to this decision? The thought and the way I'd think about this is if our smell test for FinCEN reporting, for the BOI reporting, is Could a bad guy use this to hide what's out there? Well, potentially they could. Thinking right now, they could form an entity, have it administratively terminated, but it still owns things, still owns bank accounts, still owns property. That's an entity that may still exist out there and they can transfer things around. This is probably what FinCEN was thinking about. So if you want to avoid having to report an entity and you think it's terminated, well, you need to formally terminate it. File whatever required paperwork you need to with Secretary of State or the appropriate office in your state or jurisdiction to formally terminate it, file your final tax returns. You're still going to have to report the beneficial ownership information to FinCEN. So even though we've got a deadline of January 1, 2025 for existing entities, think about it this way. It existed in 2024. And because it had existed in 2024, well, you've got to go ahead, close it down formally, then go ahead and file your reports with FinCEN. If a reporting company was created in 2024 and later winds up or ceases to exist before its initial return is due with FinCEN, does it still have to submit that initial report? The answer is yes. Companies that are created or registered in 2024 are still going to have to report their beneficial ownership information to FinCEN within 90 days of that formation. So even if you form an entity and the next day decide, we don't really need this, and you terminate the entity, you're going to have to go ahead and get that initial report in reporting who those beneficial owners are. Reporting companies created next year in 2025 are going to have to report their beneficial ownership information within 30 days. Now, these obligations are going to remain applicable to those reporting companies that cease to exist. Even when you terminate quickly, before those reporting obligations are due, you still have to tell FinCEN who the beneficial owners are. Again, what we're looking at with this is once you've formed an entity, these obligations are being triggered. Unless you're exempt, you're going to have to file a beneficial ownership report with FinCEN. So we got some new guidance from FinCEN in July of 2024 about what to do with entities that have terminated or may not have been formally terminated. Remember, when you're dealing with entities and dealing with FinCEN, make sure that you're not just taking my word for it. Work with your own advisors to make sure you're getting the answer correct for you and your specific situations. Don't forget to like, comment, subscribe. We'll see you next time.